Okay, here's the deal. The US Constitution is the oldest still active national constitution in the world, which is remarkable, but what makes it special is that it is the institutional blueprint for how the most powerful country in the world actually functions. Nothing quite like it had ever existed before it was ratified, and today, almost 250 years later, it still holds fast over the land of the free and the home of the brave. I'm Jake the Lawyer, and welcome back to Internet Esquire. All right, so out of the three documents that lie at the core of American government, the Constitution is number 2. First came the Declaration of Independence, which broke us away from Britain and established the philosophy of why America exists. Then came the Constitution, which established the operating manual for how the American government would be structured. And then came the Bill of Rights, which acts as a safety switch on liberty, protecting the American people from violations of our rights by our own government. All in all, these three documents make up the holy trinity of our federal republic and have been used as the source material for countless other governments since their origin. And if you'd like a deeper dive into the Declaration of Independence or the Bill of Rights, I have videos on those, links in the description. But for now, on to the Constitution. Okay, some people know this, but a lot of people don't. The Constitution was not America's first rodeo. The framers didn't just wake up one day and say, hey, you know what'd be great? An effectively perfect form of government that will last hundreds of years.
What about 9 million socially conscious and unified citizens all just stepping up and doing their part?
Yeah, that didn't happen. No, instead, after we won the War of Independence, separating from Great Britain, the United States of America was governed by a national document known as the Articles of Confederation. And well, to summarize it frankly, the Articles didn't really work all that well. After independence, the individual states were deeply suspicious of centralized power. Why? Because they had just fought a war against the centralized British crown. The last thing that they wanted to do was to repeat the mistakes of having a king now again in the new country. So they intentionally wrote a governing document where the central authority was weaker than the states. And in fact, under the Articles, states could do all kinds of things that would be wild to us today, including printing their own money, conducting foreign relations and signing their own treaties, and maintaining their own armies. And sure, admittedly, while a pinch more of states' rights might do us a little bit of good today, under the Articles, states found themselves constantly fighting with each other. The country itself was going bankrupt and had many debtors, and the Articles of Confederation could not be modified without unanimous consent amongst the states, which was pretty much impossible at that time. So as you can see, it was kind of a mess. Which is why in the spring of 1787, a convention was called to go over the Articles, and the delegates hammered everything out, and by the end of summer, we had what would become known as the United States Constitution. We got these 13 herbs and spices, and we got America 2.0.
KFC original recipe chicken.
Heck, now we got 50 herbs and spices. But don't get too confused here. The new federal government didn't just magically spring into place once the framers all signed their John Hancock on the document. Even though John Hancock signed the Declaration of Independence, it's fine, it doesn't matter. Moving on. The point is, the Constitution still had to be ratified and implemented, and the fight over ratification began almost immediately, split between the Federalists and the Anti-Federalists. Now, you've probably heard of them before, or at least heard of the Federalist and Anti-Federalist papers, but essentially the Federalists were in favor of a stronger, centralized government with power limited by the Constitution, and the Anti-Federalists were in favor of a union, but wanted a weaker, more decentralized system similar to the Articles of Confederation. And I'm generalizing here, but that's the gist of it. Anyway, the Federalists argued that the Articles had failed and that the new Constitution was necessary to create a stronger, more perfect union under the new federal government. And the Anti-Federalists feared that such a government could risk becoming a dictatorship. So they argued for a Bill of Rights to be added to that Constitution in order to protect individual liberties from federal overreach. And it is exactly this compromise on the Bill of Rights which is what allowed the Constitution to actually become ratified. You have to remember, at the time, there was no central authority that was strong enough to bind the states together by force. No, they actually had to all come to the bargaining table and decide to do it together. So with the promise of the Bill of Rights now in hand, the Constitution was ratified by the necessary number of states, and it went into effect in early 1789. And with all of that, we didn't just have a new federal government on paper, we had the world's first real federal republic in practice. A lot of people don't know this either, but the Constitution, as it was originally written, fit onto just 4 pieces of parchment paper. In modern printed book format, that is only about 25 pages, including all of the amendments. In fact, it's incredibly short for how important it is, and this is due in part to the idea of limited government or negative powers. Unlike most other forms of government which had come before it, the Constitution did not grant all authority and sovereignty in a king or in a central government, and then delegate some of it back to the states and to the people. Instead, it flipped this concept entirely on its head. In the American government, power does not originate with the king, it originates with the people, and this power pre-exists any form of government in the first place. The people then consent to be governed for the better protection of their rights, delegating away only the amount of authority that is absolutely necessary in order for the government to do its job. This is limited government, which is the same as the idea of bounded power, wherein the government only has the power that has been given to it, and it must exercise that power within fixed boundaries. And this is exactly what the Constitution was designed to do. Thus, the federal government can only do what it has been explicitly given the power to do, nothing more. And this is also exactly why it is no coincidence whatsoever that the first 3 words of the Constitution are "we the people." Because it's not just saying, okay, here, we got together, we wrote a Constitution, and here's what we think. No, it is saying we, the people, is where the authority for this government originates. We call this first sentence of the Constitution that begins with "we the people" the preamble, because it introduces why the Constitution exists, and it lays out its intentions. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, which is sort of a calling back to the language of the Declaration, which is kind of cool, do ordain and establish this Constitution for the United States of America. But the preamble does not begin the actual work of establishing the new government. This begins in the next 7 articles that come immediately after it. And while we won't cover every single thing that is in the Constitution because this video is still just an overview, just know this: the Constitution is put in the order it is put in for very particular reasons, and it all begins with the bicameral legislature. So, let's follow the logic. The very first sentence of Article 1 says this: all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. This, by definition, is a bicameral legislature. The word bicameral means 2 chambers in Latin, and the word legislature is a combination word in Latin, beginning with legis, which means law, and latus, which means to propose or to bring forth. So the word bicameral legislature actually literally means the 2 chambers by which laws are brought forth.
That's Latin, darling. Evidently, Mr. Ringo's an educated man.
Now let me ask you a question. Why would this be first? And if you thought, because the sovereignty of the United States originates with the people, then yes, you would be exactly right. Good job. The first thing the Constitution does in terms of actual practical governance is establish the Republican body by which laws are brought forth from the American people. You gotta love that. Article 1 then goes on to set up the House of Representatives in Section 2 and the Senate in Section 3. And again, this wasn't arbitrary. There were very specific reasons for this. The House of Representatives is listed and created first because it is the lower house. It is the people's house. Not because it is somehow inferior to the Senate, but because it is more grounded to the people, to the everyday American, and in exchange, it is also more subject to the will of the everyday American. That is why members of the House are chosen by election every 2 years. You only need to be 25 years of age in order to become a member, and why the House has way more seats than the Senate, 435 seats to be exact. These seats then are distributed amongst the states based on their population, or what we call apportionment, and they can and do change. I'll give you an example. As recently as 2020, Texas gained 2 House seats, while Florida, Montana, and North Carolina all gained 1. And California, Illinois, Michigan, and New York all lost 1 seat. And the migration out of those states in recent years directly led to this outcome in the House. So whoever says you can't vote with your feet is dead wrong. Anyway, Section 3 largely does the same thing but with the Senate, and with the Senate being the upper house. It is specifically designed to be the upper house because it is not as close to the everyday American and therefore not as subject to the whims and passions of direct democracy. Section 3 lists the limits of 2 senators per state, a minimum age requirement of 30, and election terms of 6 years, but with one huge departure from the House of Representatives in Section 2. You see, up until 1913, with the passage of the 17th Amendment, senators were actually picked by the legislatures of the state they were from, rather than directly by the people from that state. Again, this was to remove a layer of direct democracy from the Senate, with the intention being to make it a more stable force focused on long-term public benefits, while also not having senators be completely immune from the people they represented. And then we get to Article 1, Section 8, which, in my opinion, is one of the, if not the most important section of the entire Constitution, and you've probably never even heard of it. It's called the Enumerated Powers of Congress. Do you remember that limited government thing I was talking about earlier? Yeah, this is specifically where that idea comes into play. Section 8 is just effectively a laundry list of powers given to Congress by the people. And the vast majority of all federal law that comes out of Congress points to a power that is written down in Section 8 as the source of authority for Congress to make whatever law it's making. Because remember, under the theory of negative powers, Congress cannot do anything that it has not been explicitly given the power to do. And the enumerated powers list of Section 8 is the one that is most cited simply because it lays out the most amount of powers that Congress has, including powers such as the power to lay and collect taxes, borrow money, regulate commerce between the states, coin money, establish the post office and post roads, promote the progress of science and useful arts, otherwise known as the Intellectual Property Clause, create courts below the Supreme Court, declare war, raise armies and a navy, call forth the militia, and the mother of all powers, the Necessary and Proper Clause, which says that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Now, I'm not going to get into each one of these powers because each one is in and of itself at least an individual video, and I've already done one on the Commerce Clause, but boy, oh boy, has this authority been stretched to its limits over the years. Here's how. You see, Congress doesn't just point to one of these enumerated powers when drafting a bill. In practice, they often both cite the power itself and the Necessary and Proper Clause. And it is this combination, when combined with the Supremacy Clause of Article 6, which we'll talk about in a little bit, which so often gives Congress the legal advantage in getting their way with effectively whatever laws they want. Anyway, that's about it for Article 1. Next, we get Article 2, which establishes the executive branch and the office of the president. And again, thinking logically, walk this through. The power rests with the people. The legislature is then elected among the people to bring the laws forward. And the executive branch, headed by the president, is there to bring the laws into effect, to actually execute the law. And this is precisely what Article 2 does. Section 1 creates the offices of the president and vice president. It sets the president's 4-year terms, explains how states have electors who elect the president through the Electoral College, and lays out the other basic qualifications for who can be president, which, in case you were wondering, are this: a natural-born citizen, at least 35 years old, and a resident of the United States for at least the last 14 years. And here's a funny one. Did you know that originally the president was the person who got the most electoral votes, and the vice president was the runner-up in electoral votes? Can you imagine that today? Yeah, they got rid of that kind of right away with a new amendment, the 12th Amendment, in 1804. Anyway, Section 2 establishes the presidential powers, including the big one, which is the Commander-in-Chief power, which says that the president shall be Commander-in-Chief of the Army and Navy of the United States and of the militia in the several states. And this is another classic example of the separation of powers being weaved into the fabric of the text as we read through each section of the Constitution. Congress has the power to declare war and the power of the purse, meaning that they can choose to declare war or they can choose to not fund a war if they don't like it. And the president is the commander-in-chief of the military when war powers are used. Now, I know I can hear you commenting already about how the declaration of war power hasn't been used since World War II and yada, yada, yada. Look, I'm just trying to show you examples of how the separation of powers is weaved into the text. If you want to get more into the presidential wartime power specifically, I have a whole video called Is the Iran War Illegal? Which I get into all that. So you can go over there if you want to. But anyways, let's keep moving. Section 2 also gives the president the authority to make treaties upon 2/3 approval from the Senate. It gives him the authority to nominate ambassadors, judges, and other public offices, typically subject to Senate approval. And of course, the authority to grant pardons. Section 3 then describes the presidential duties, including recommending important issues to Congress, informing Congress of a regular state of the Union, and to take care that the laws be faithfully executed. Now let me pause here for a second. This take care clause in Article 2 is effectively equivalent to the necessary and proper clause of Article 1. And yes, in case you were wondering, it has been used by presidents to stretch the meaning of executive authority to, well, effectively the outside maximum. And finally, in Article 2, Section 4, it says that the president can be impeached, specifically this: can be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Probably a good thing to just keep that one in there just in case. Article 3 then creates the judicial branch, which again, if you follow the political philosophy, the logic makes sense. Once you've created the body to make the law and the body to execute and enforce the law, you now need the body to solve disputes. And while we often look at the judiciary today and say, well, they're the body that interprets the law, this idea was not actually written into the Constitution. It wasn't until the 1803 case of Marbury versus Madison where the Supreme Court established the doctrine of judicial review, meaning we are the ones who are going to interpret the Constitution. And while there is definitely a separation of power issue with the Supreme Court deciding for itself that it would be the branch to interpret the Constitution, let's just put that aside for another video. The fact of the matter is that this practice has been around for 220 years now, so I think that's pretty much settled at this point. And what the actual text of the Constitution says about the judiciary is pretty simple. Section 1 creates the one Supreme Court and then allows Congress to make lower courts underneath that court, which again is a nice separation of powers. Hey guys, let's not let the Supreme Court decide how many courts should be underneath it. Let's separate those things so there's never a conflict of interest. Section 1 also establishes that judges can serve in their capacity as judges effectively for life or for so long as they have good behavior. And the concept here of having non-elected judges is to preserve the idea of what we call judicial independence, and again, not have them subject to elections or the whims or passions of direct democracy. And although everybody seems to have an opinion as to whether or not Supreme Court justices should be elected, I think if we look at the intention of the Constitution and how this was a balance of powers meant to preserve judicial independence, and the framers specifically designed it this way, what good reason would we have to change that almost 250 years later? Article 3, Section 2 then does something interesting. It defines specifically the types of cases that the Supreme Court can hear, separating a clear line between original jurisdiction and appellate jurisdiction. Now that might sound all fancy and everything, but it's actually fairly straightforward. In practice, we often think of the Supreme Court as the final court of appeal, meaning that it hears cases that lower courts have already heard and decides important matters of law that the lower courts cannot seem to agree on. The lower courts appeal to it, and the Supreme Court then tells them how to proceed. In this sense, the Supreme Court has appellate jurisdiction. But it also has original jurisdiction, as per the text of the Constitution, where it can hear cases directly and for the first time. Specifically, cases involving ambassadors or other public ministers, or cases where a state is one of the parties, have original jurisdiction within the Supreme Court. Article 3 also establishes trial by jury, sets the definition for treason against the United States, and gives Congress the authority to determine what the punishment for that treason is. And there's one kind of cool thing in here that I just thought was interesting. It puts a limit on how much Congress can punish somebody for treason, with the idea of a doctrine called the corruption of blood. Now, if you're wondering what that is, it's sort of what you're already kind of thinking of. It's the idea that Congress cannot put a punishment on everybody who is part of somebody's bloodline, specifically just because that person committed treason against the United States. It's like saying, hey, guys, look, you can punish him however you want, you can put him to death, but you can't punish his entire bloodline because this guy over here committed treason. I know. Under the Articles, we could.
We used to be a proper country.
Anyway, that's the judiciary. Okay, Article 4 is often referred to as the State Relations Article because it sets the new rules for how the states must now deal with each other now that they are under the new federal union going forward. And again, the framers put Article 4 as Article 4 because it follows the same political logic. Now that you've created the 3 different branches of government and you've begun to establish the separation of powers, it's now time to tell the states how they need to act going forward so that we don't make the same mistakes under the Articles of Confederation, and we ensure that the states' actions now fit the federal mold, and this is exactly what Article 4 does. It establishes the full faith and credit clause, which says that states must give other states full faith and credit when it comes to public acts, records, and judicial proceedings of every other state. In English, this simply means that the courts must recognize the authority of every other state, especially when it comes to things like records and judicial proceedings. Article 4 also establishes the Privileges and Immunities Clause, which says basically this: no one state can deny a citizen basic rights simply because they are a citizen of some other state. So for example, the state of Florida cannot deny citizens from Tennessee who are currently in Florida of the same basic rights of Floridians simply because those people are not from there. Article 4 also does things like require states to deliver somebody to justice in another state that they may have committed a crime in. And while most of this seems pretty obvious to us today, at the time the Constitution was written, it was anything but this under the Articles of Confederation. And finally, Article 4 establishes the way in which new states can be added to the Union and requires a guarantee that each state provide a republican form of government to its citizens, which again was not necessarily a guarantee at the time. Okay, moving right along, Article 5 primarily establishes the way in which amendments can be added to the Constitution, and we still function this way today. It explains both how amendments can be proposed and how they can be ratified. Amendments can be proposed if 2/3 of both houses of Congress agree, or if 2/3 of all state legislatures agree. And once proposed, an amendment must then be ratified before it can officially become a part of the Constitution. Ratification can occur if 3/4 of all state legislatures approve. But it is Congress that gets to decide the method for ratification. We then get to Article 6, which is often referred to as the National Supremacy Clause. And while we touched on a little bit of this earlier, the National Supremacy Clause is fairly straightforward. It says that the Constitution and all federal laws that result from it are the supreme law of the land. Meaning, when valid federal law conflicts with state law, federal law wins. State judges are bound by this supreme law even if their state legislatures say otherwise, and state legislatures are bound by this supreme law even if they decide otherwise. And the Supremacy Clause is important not just because it bolsters congressional authority to act, but also because it was a huge departure from the Articles of Confederation. It really drove home this idea that the new federal government was going to have the final word. But you can also begin to see how when this was combined with the Necessary and Proper Clause, the Anti-Federalists got a little bit uncomfortable about how powerful this new central government might actually become. Because if Congress can just make any law that's necessary to one of their enumerated powers, and that law becomes the supreme law of the land, what is really the purpose and point of state law then anyway? And honestly, this is still a legitimate question today, and it's one that we've been fighting about since the beginning of our country, and we even fought a civil war about 170 years ago. two more interesting things about Article 6. It also carried over all of the debts that the United States had from under the Articles of Confederation, which was simply important from an international standpoint to maintain legitimacy. And Article 6 also laid out that no religious test would be required for holding public office at the federal level. You have to remember, states at the time often had their own established state churches, which required either a religious test or at least a religious affirmation in order to hold public office in that state. So Article 6 is mostly the National Supremacy Clause, but it does a few other things as well. And then finally, we get to old, sleepy Article 7, the mechanism by which the Constitution would be ratified. Obviously, this isn't super important to us today because, well, we know the Constitution was ratified, but it was very important at the time it was written because it established exactly how this thing was going to go into effect. For us today, the takeaway of Article 7 is simple. It shows a clear line of how a government that was designed from the consent of the people took effect directly through that same consent. And this idea and this practice was both in keeping with the philosophy that the Constitution was bringing forward and in keeping with the natural law it was deriving its authority from, which I think is pretty cool, and hopefully you can appreciate that as well. So that's the Constitution, and yes, we have ratified the Constitution 27 times since it was ratified, but honestly, that really isn't all that many, considering the fact that over 11,000 amendments have been proposed since the beginning. And on a more philosophical level, the question often gets asked today whether our federal system and our Constitution still works for America. Now, obviously, America is not without its problems, but the next time you see something and say to yourself, hey, this is a major problem, I want to encourage you to ask one simple question. Is this a problem with the American government, or is this a problem with Americans? Because after all, if you're American, the authority for the Constitution itself begins with you. It does not begin with your government, or how it operates, or what it can do for you. And don't get it twisted, that is not me saying that the federal government is somehow innocent in all of this. No, they have taken their authority way beyond the reach of the Constitution. I think we can all see that. And of course, we can and should take steps to fix this, but I think all too often we just simply blame the system rather than taking a look in the mirror and going, am I part of the problem? Anyway, that's it once again. I hope you learned something and I hope you enjoyed this video. We keep growing in subs and we are fast approaching that 100,000 silver play button sub number, so I can't thank you all enough for your support. Consider subscribing if you liked this episode. Leave a comment below for other video topics you'd like to see me do. This one in particular was highly requested, and it is because of those comments that I ended up making this video, so thank you. And lastly, for all you Pepperbacks out there who have been asking whether or not this show is going to be on Pepperbox, the eventual answer is yes. We're hoping to do that sometime this summer or perhaps this fall. Just depends, honestly, on your support. So anyways, that's it. I hope you truly have a wonderful day, and I will see you on the next one. Bye.